Thank you, Mr. Hibner, and thank you, counsel, for joining with Judge McClarty and Judge McBrayer and me as we hear your arguments this afternoon. I understand we'll have an announcement, but we'll do that after Mr. Hibner calls our case. Please recall that each side will have 15 minutes for argument, and I believe the appellant has already reserved a part of that for rebuttal. We will conduct the hearing in the same fashion as if all of us were in the Supreme Court room together. So without further ado, please call the case and then we'll have the introduction.
Benjamin Jordan Frazier et al. Versus Tennessee Department of Children's Services.
All right. Good morning. Good afternoon, everyone. And I understand that Mr. Weaver has an introduction.
Yes, sir, Your Honor. Good afternoon, Your Honors. I've had the privilege of arguing in front of some of you over the years, but today my associate, Meredith Brasfield, is before you. She works for me, Weaver and Craig PC. Ms. Brasfield is a graduate of the of Birmingham Southern, got her Bachelor of Arts in 2008. She graduated from Mississippi College School of Law in Jackson, Mississippi in 2012. Obtained her Tennessee license in 2012, her Mississippi license to practice law in 2013. She has worked, I'm the only attorney she's ever worked for, so she's sort of my pride and joy here, and this will be her first time to argue before the Court of Appeals. I'll also mention she is a member of the Academy of Adoption and Assisted Reproduction Attorneys, and I certainly present her to you with the privilege of doing so. Thank you.
Well, thank you, Mr. Weaver and Ms. Brasfield. We're pleased to welcome you as you appear before this court for the first time, and I hope you can overcome the mentoring, the deficient mentoring that Mr. Weaver has provided over the years. With enough said, we now will hear from the appellant.
Thank you, Your Honor. May it please the court, my name is Amber Seymour. I'm with the Attorney General's Office on behalf of the Department of Children's Services. At this time, I would like to reserve 2 minutes for rebuttal.
Very good.
Your Honors, this case is an appeal of an administrative decision of DCS that denied the appellee's application for adoption assistance for 2 children that they seek to adopt. The issue before the court is narrow: whether DCS properly denied this application because the children had not been placed in the care of a placement agency pursuant to an order that found continuing in the home would be contrary to the children's welfare. The Chancery Court, upon judicial review, reversed the DCS decision. And for 2 reasons, the decision of the Chancery Court should be reversed and the department's denial of the application should be reinstated. First, the denial was consistent with the language of the federal statute. And second, the department properly relied on its own policy in denying the application. Title 4E of the Social Security Act provides funding for separate programs that are administered in Tennessee by the Department of Children's Services. 2 such programs are the Foster Care Maintenance Payment Program and the Adoption Assistance Program. There are separate statutory eligibility criteria for each program. 42 U.S.C. Section 673 provides the statutory adoption assistance eligibility criteria. There's no dispute in this case that the children meet all the criteria except for one, and that is they were not placed in the care of an agency pursuant to an involuntary removal from an order that found that continuing in the home would be contrary to their welfare. So the facts in this case are largely undisputed, and I'm just going to highlight the ones that inform this particular issue. In 2013, the children were removed from their biological parents and they were placed in DCS custody. There is a 2013 dispositional order from the Dependency and Neglect Proceedings in the record. That order has the finding that continuation in the home would be contrary to the children's welfare. So that is an undisputed finding. In 2014, the juvenile court awarded a subsidized permanent guardianship of the children to their aunt and their uncle. And then in 2015, the uncle petitioned to modify that guardianship. At that time, the juvenile court magistrate called the Tennessee Baptist Children's Home and asked if they would take custody of the children. DCS was not a party to that proceeding. They did not have custody at any of that at that time. And that order is pretty sparse. It's not clear what the circumstances of that disruption were. It just states that the children are removed from the aunt and the uncle, the guardianship is terminated, and that custody is given to the Tennessee Baptist Children's Home. That order did not have a finding that continuation in the home would be contrary to the children's welfare, and that is also undisputed. Tennessee Baptist Children's Home then placed the children in the care of the appellees, and the appellees are now seeking federal adoption assistance to adopt the two children. So the issue really comes down to this: which order? The 2013 order that removed the children from their biological parents, or the 2015 order that removed the children from their aunt and their uncle? Which of those orders was the proper order to consider when reviewing the adoption assistance application? Stated another way, where was the children's home at that time within the meaning of the federal statute? So looking at the language of the statute, the 2015 order that removed them from the guardianship of the aunt and the uncle was the proper order to consider. The eligibility criteria at issue here in section 673 of the federal code is this: the children must be placed in the care of a public or licensed private child placement agency at the time of initiation of adoption proceedings. And here, that would be the Tennessee Baptist Children's Home. That was not DCS. This must be pursuant to an involuntary removal of the home in accordance with a judicial determination to the effect that continuation in the home would be contrary to the welfare of the child. So it was the 2015 order that gave the Tennessee Baptist Children's Home custody of the children. That is who has custody at the time of these adoption proceedings and this time of this application. It was not DCS. The 2013 order that's relied upon by the appellees gave custody to DCS. There's no definition of home under Title 4E. Black's Law defines it as a dwelling place. The guardianship was certainly a dwelling place in this instance. But as a matter of statutory construction, there's another part of Title of the Social Security Act, that we can look at. So Title 4A has a definition of home. Even though it's not controlling in this instance, it does give some insight as to what Congress had in mind when they used the word home under Title 4E, and specifically with the adoption assistance eligibility criteria. And so there's two parts of this definition I want to highlight. The first is what qualifies as the home. It provides a home is a family setting that's maintained or in the process of being established, as evidenced by the assumption and the continuation of responsibility for the day-to-day care of the child by the relative with whom the child is living. The aunt and the uncle were the relatives with whom the children were living in 2015. Under Tennessee law, they had a myriad of rights and responsibilities as the permanent guardians. They are required to
Does it make a difference that the aunt and uncle were permanent guardians versus temporary guardians?
In this situation, it does. So the permanent guardianship is also provided under Title 4E, which is something that hasn't really discussed much before today. But under Title 4E for a permanent guardianship, the point is that the guardian is supposed to be permanent. This is supposed to be a permanent placement. This is not a temporary placement like there is for foster care placements. Once the aunt and the uncle assume this permanent guardianship, the idea is that that's where the children will stay forever until at least 18. It's not.
So would you concede then the result here would be that the prospective adopted parents would get assistance had this been a temporary guardianship?
Your Honor, I think I would need to know more about what the specific temporary guardianship is. I believe my answer is correct, but without knowing specifics about whether it would fit into this definition of the family unit and the day-to-day responsibilities, the purpose of comparing the foster care maintenance payments versus the adoption assistance criteria. Foster care, of course, it's supposed to be temporary. At some point, the idea is that the children either get returned to their parents or they move on to a more permanent placement, whether that be the foster parents adopting or somebody else taking in these children permanently. And so here they were according to the record, the children were in the foster care of the aunt and the uncle before they entered the permanent guardianship of the aunt and the uncle. because one criteria to enter that guardianship is that the children must be eligible for the foster care maintenance payments for 6 months prior to that guardianship beginning. So once that guardianship started, that was supposed to be permanent. Even the eligibility criteria for the guardianship under Title 4E talks multiple times about how this needs to be, the parties must intend this to be a permanent place for the children. So going back to this definition under Title 4A, it also tells us when a home expires, not just when one starts. It states a home exists so long as the relative exercises responsibility for the care and control of the children. After the children were removed from the biological parents, they never again exercised this care or control. The children were never returned to their care legally or physically. It was the aunt and the uncle who had full responsibility for the care of the children while in this permanent guardianship.
So really, it wasn't nothing permanent about the guardianship. It was temporary.
It was, so they met the criteria for it to be a permanent guardianship and even for it to be a subsidized permanent guardianship under federal law. It's just in this situation, it's very unfortunate that it ended up not becoming permanent, but it's no different than if a child was adopted, and in that sense, it's a permanent placement. And then maybe later the children unfortunately had to be removed from the adoptive parents. It was still permanent, even though later it ended up being disrupted.
Now, DCS has a policy and procedure that relates to this adoption and assistance, correct?
Yes, Your Honor. So just as there are two separate statutory provisions, there are two separate federal regulations for the separate programs, and DCS also has two different policies for the programs. But when you look at the regulation, the federal regulation for adoption assistance, it's not very detailed. It doesn't give much information on how to actually implement the eligibility criteria. And so what we know from the Department of Health and Human Services Child Welfare Policy Manual, which is relied on by both parties, is that some of the explanations that are given in the federal regulation for the foster care maintenance payments still apply to adoption assistance. And so here, there's a requirement under the foster care maintenance payment CFR that contrary to the welfare finding, that must be in the first order, even that removes the children even temporarily from the home. Again, there's still no definition of home within that regulation. But according to the Child Welfare Policy Manual, that provision still applies to adoption assistance. And that's not disputed by the parties. The Chancery Court and both parties agree on that. Where the disagreement comes is when DCS relied on its policy that implements that very provision from the foster care maintenance CFR. And so they do have two policies, but the policies track the language of the two different CFRs. And since we know that the requirement in the foster care CFR also applies to adoption assistance, the department relied also on its policy that relates to that specific foster care maintenance CFR and that provision at issue.
Well, I want to ask you though specifically about the policy that relates specifically to adoption assistance. If I look at policy 15.11, which criteria here under A part do these prospective adopted parents which ones don't they meet?
Your Honor, I apologize. I don't have that specific policy directly in front of me, but the way that the two policies are structured, specifically 15.11 for the adoption assistance, it tracks just the language of the adoption assistance statute and the adoption assistance CFR. And so that's why the department has to then look at its foster care maintenance policy, because that is where the requirement from the foster care CFR of a continuation of the home being in the first removal order, that's where that comes from. And so that's why it's not.
Let me ask you about the department's policy though. It seems like to me they would want to apply the policy that relates to adoption assistance rather than looking at another policy. So I have it here in front of me. It's in the record. It says, in order for a child to be eligible for adoption assistance, the child must meet all of the following special needs criteria. A, DCS determined the child cannot or should not be returned to the home of his or her parents. That's true, correct?
Yes, Your Honor.
Yeah. And then efforts have been made to place the child without providing adoption assistance. True, yes?
Yes, Your Honor.
Okay. And C, DCS must determine that there exists a specific factor or condition because of which it is reasonable to conclude the child cannot be placed with adopted parents without providing adoption assistance. Yes?
I'm sorry. Could you repeat that one? I have someone hammering outside. I'm so sorry.
Oh, all right. So you guys must be in your new building then.
I'm actually at home today.
Oh, okay. All right.
We're moving very soon. I'm not moving, but soon it will be happening.
DCS must determine that there exists a specific factor or condition because of which it is reasonable to conclude that the child cannot be placed with adopted parents without providing adoption assistance or Title 19 medical assistance, TennCare.
Yes, Your Honor. The department does not dispute that every other criteria is met except for the.
Well, you say, I mean, I'm sorry to interrupt, Ms. Seymour, but you say every other criteria. It seems like to me every criteria of your specific policy that relates to adoption assistance is met in this case. So I'm wondering why we are going to, it's almost like you're saying, well, just ignore what our policy says, look at our other policy, and that puts a gloss, or we use that and interpret 15.11. Is that, I mean, what am I missing on that?
Your Honor, I see my time has expired. May I briefly answer your question?
Sure.
So I have two responses to that. The first is that, yes, DCS policy, the policies, there are two different policies. I understand that it is very confusing that we have to jump to a different policy to understand the adoption assistance, and that it would make more sense to look just at the adoption assistance policy. But the policies were based to reflect how the federal government structured their law, and that's how it was structured in the federal code and the federal regulations. And so that's why they're separate like that. But my other point is that DCS in this situation does not even have to look at its policy, because you can look just at the language of the statute and of the federal regulations to determine that it was the 2015 order that was proper. And I'll discuss that more on rebuttal, Your Honor. Thank you.
Ms. Seymour, let me ask you one more question before, because I don't want to take any of your time up for rebuttal. If we look at, well, I'll tell you what, I want to hear from Ms. Brassfield, and I'll get back to you. Thank you, Ms. Seymour.
Thank you.
All right, thank you, General. Ms. Brassfield.
May it please the court. As you've heard, my name is Meredith Brassfield, and on behalf of Weaver and Craig PC, we represent Benjamin and Audrey Frazier, the appellees in this matter. Mr. and Mrs. Frazier are the prospective adoptive parents of the minor children that are subject to these proceedings, and the minor children have now been in the care of Mr. and Mrs. Frazier for over 4 years. I'd like to first start out with what the purpose of the federal Title IV Adoption Assistance Program is. It is to provide permanency for children with special needs by assisting states in providing ongoing financial and medical assistance on their behalf to the families who adopt them. The Child Policy Manual states that foster and adoptive parents are not recipients of the federal foster care and adoption assistance payments. Rather, foster care and adoption assistance payments are made on the child's behalf to meet his or her needs. These types of needs that this program supports are varied and often very costly to adoptive parents. The minor children in this case have experienced trauma, and that trauma has led to certain medical and social needs. And the denial of Mr. and Mrs. Frazier's adoption assistance applications by the department is based upon an inaccurate interpretation of federal law and thereby an inaccurate application of its own state policy. This denial in itself is contrary to the children's welfare, and it prohibits Mr. and Mrs. Frazier from effectively meeting the needs of the children once they are adopted. I'd like to also point out for the court that the standard of review here is a de novo review. The facts are undisputed, and in reviewing the interpretation by the department of the federal law, the standard would be de novo. And we understand that there is deference to the department when it's interpreting its own state policies, but when that policy is plainly erroneous and inconsistent with the regulation, that deference is not required. The department's denied Mr. and Mrs. Frazier's application, and the Chancery Court, the lower court, reversed this decision, and we ask that you do the same. I would like to focus on a few facts that the department did not point out. The children at the time of their initial removal were ages 1 and 3. They experienced a horrific event in which their mother, who was diagnosed as with schizophrenia, attacked their 4 older siblings. This incident is what led to the department removing these children. And it's important because this removal was an involuntary removal. The children have never returned.
But there wasn't an involuntary removal though from the aunt and uncle, correct? I mean, that was a voluntary relinquishment of rights.
Yes, Your Honor. That's the point. The federal regulation specifically has, and I have it in front of me here, it speaks to an involuntary removal. So under the federal regulation 45 CFR 1356, which speaks to adoption assistance, which is what the Mr. and Mrs. Fraziers have applied for, says that the child meets the requirement of this paragraph that at the time of the initiation of the adoption proceedings was in the care of a private agency, which this child was in the care of the state agency, Tennessee Baptist Children's Home, pursuant to an involuntary removal of the child from the home in accordance with a judicial determination. That was contrary to the welfare of the children.
So that presumes the aunt and uncle's residence wasn't the home for the children, even after the permanent guardianship.
Yes, Your Honor, at the time of the 2013 removal, these children became Title IV-E eligible, and that never changed. Yes, Your Honor.
So you're saying it follows the children?
It follows the children. That's the difference. I believe your question to Ms. Seymour earlier, that's the difference between a permanent guardian and a temporary guardian. The permanent guardianship, it was subsidized. These children were receiving funding from, once the department lost custody, they continue to receive funding for these children because the department recognized the needs for these children. And so it would follow the children.
The proceedings below were stayed in order for the state to consult with the Health and Human Services to ask if their interpretation was consistent with federal law. And I'm assuming by the fact that the stay was lifted that HHS agreed with the state's interpretation. Is that fair to say?
That's not fair to say, Your Honor. We've not received any guidance from the U.S. Department.
Okay.
So looking at that 2013 order, I've made the point about the involuntary language. I'd like to point out that in the state's own policy, 1511, it does not speak to an involuntary removal. It only says removal of the children. And so this is important for a federal funded program. Mr. and Mrs. Frazier did not apply for state funding adoption assistance. They applied for federal adoption assistance. So you must look at the federal language. The federal language speaks to an involuntary removal. Also, the federal language speaks to the contrary to the welfare determination being made in the first court ruling. Now, the first court ruling is defined in the foster care maintenance section of the federal statute, but the child policy manual, which clarifies certain types of situations, speaks directly to whether or not that definition applies to adoption assistance. And so the definition for contrary to the welfare specifically states in the question and answer section of that policy manual, 82B7, the question is, does the contrary to the welfare requirements apply to adoption assistance program? And the answer is yes. And if you look down towards the bottom of that answer, it states that since a child's removal from the home must occur as a result of a judicial determination, the determination must be made in the first court ruling that sanctions even temporarily the removal of a child from the home. If the determination is not made in the first court ruling pertaining to removal from the home, the child is not eligible for Title IV adoption assistance, pursuant, again, to an involuntary removal order. And so it is only reasonable for the 2013 order to be the controlling order. In fact, the 2013 order controlled the outcome of the other orders that were made after these children followed through guardianship and into the Tennessee Baptist Children's Home's care. In 2013, they were removed. In 2014, they went into the guardianship. And at that time, the 2014 order specifically stated that the guardians were to not return the children to the care of their birth parents without filing an appropriate petition with that court, the Juvenile Court of Shelby County. And that's exactly what they did. Less than a year later, they filed a petition to modify their guardianship. It was under the same docket number, under the same case. It was a continuation of the dependency and neglect proceedings. It was not a new case. It was not a new custody episode. It was a continuation of the 2013 removal. And so the juvenile court, in following that petition to modify, looked to a new placement for these children. It was a very unique situation. It is unfortunate that the guardianship disrupted, but in modifying that guardianship order, the state statute requires that the court, when modifying a guardianship, looks to certain factors. And Tennessee's own state statute 37-1-806 requires that when a court modifies or terminates a guardianship, that there must be a substantial change in the material circumstances, which there was here with the guardians filing a voluntary petition to modify. There was no allegation of abuse. There was no new redetermination of a dependency and neglect. This was a modification. And then further, a court, when they're reviewing and modifying or terminating a guardianship order, must consider whether there has been resolution of the factors in the home that resulted in the adjudication of the child as dependent and neglected. So the juvenile court was required to look back in the case file and determine whether or not the birth parents were a viable placement before ever modifying guardianship. And so we've heard that that was the case. The juvenile court called Tennessee Baptist Children's Home seeking to make this placement and merely transferring the custody of these children to Tennessee Baptist Children's Home. I'd also like to point out that Tennessee Baptist Children's Home is a state agency, but they do not receive any state funding. They will not receive any funding if the adoption assistance is granted. They are merely there to assist families like Mr. and Mrs. Frazier to apply for this federal adoption assistance because they recognize the needs for the children. At the time of the administrative hearing, these children had IEPs in their school for developmental delays. One of the children, the child needed a psychological evaluation, and all of these needs are manifested from the trauma that they endured as babies in that first removal order by the department. I'd also like to speak to the home definition that the department has put forth today. The home definition is not found in any of the federal regulations or statute as it relates to adoption assistance. But if you do take a look at the department's own state policy, 1511 for adoption assistance, it speaks directly to the removal of the child from the home of his or her parents. It does not speak to the removal of from a relative or a guardian. It speaks to the removal of from the child's home. It's because once there has been an original removal from the birth parent's home, that eligibility never goes away. For adoption assistance, it may be different for foster care, as there are different custody episodes, but those types of redeterminations or for each custody episode is not required under federal adoption assistance. Your Honors, again, these two separate programs, the foster care maintenance and the adoption assistance, essentially the department has applied its foster care policy in denying the adoption assistance for Mr. and Mrs. Frazier. They have conceded that they are two different programs, and those redeterminations are only required for foster care maintenance. Again, the Child Welfare Policy Manual specifically says that there is no requirement for redeterminations for adoption assistance. And that's because when the needs are recognized for this adoption assistance program, they're supported after the adoption. the payments are made for two different types of situations when the children are in foster care versus after they are adopted. And so that is what Mr. and Mrs. Frazier are asking for. They're asking for these payments in order to help assist them once they are able to adopt these children. And frankly, if you go back to the purpose of the adoption assistance program, it's to secure permanency for these children. But with the department's denial, the permanency for these children has been delayed. For 4 years now, they have waited to be adopted. And for all these reasons, we are respectfully requesting that the Chancery Court of Williamson County be affirmed and that the department's decision to deny federal funding to Mr. and Mrs. Frazier be reversed.
Thank you, Ms. Brassfield, and we'll now hear rebuttal from General Seymour.
Your Honor, may it please the court, briefly on rebuttal, I have 2 points. The first is opposing counsel has mentioned a redetermination requirement, and I just want to clarify that there is never a redetermination here. To redetermine something, it must be determined in the first instance. The children had never been determined eligible for adoption assistance. Yes, they had been determined eligible for foster care maintenance, but as everyone seems to agree, there are different eligibility requirements for the different programs. And so just because the children were eligible for foster care payments does not mean that they are automatically eligible for adoption assistance. Second, I want to go back to the definition of home, but not necessarily just looking at the Title IV-A definition, but for a precedential purpose, this court needs to remember that this is going to affect other children in other cases and not just this specific fact pattern in how to interpret this federal statute. To read home as solely relating to biological parents, this ignores the more fluid understanding that we have of home and family in today's society. Under a limited interpretation where a home is only biological parents, a child's home may never change, even when, as the case is here, children are very young and they're removed from their biological parents and never return to those parents. This then calls into the question of how this would apply in other situations, such as where children are abandoned very young and the parents never assume custody or ever take control of the children. We know of many situations where children are raised by other relatives for most of their lives. And in those situations, there's usually not an order removing the children from the biological parents that's going to fit this definition. It cannot be that Congress intended for any type of removal to only be from the biological parents, because there's just too many situations where the removal or children not living with their parents is caused by other reasons other than the involuntary removal where continuing in the home would be contrary to their welfare. So for these reasons, we ask that the Chancery Court be reversed. Thank you.
Thank you, General Seymour and Ms. Brassfield, for your arguments. Both are very convincing, and we'll have some work to do to resolve this issue. So we'll take the matter under advisement. Mr. Hibner.
This honorable court is now in recess until 2 p.m.
Thank you, sir.